Good day, everyone. Welcome back to Frontlines and Faultlines with Mike Kelly. We're really going to pick up where we left off last week in the good fortune we've had of having Professor Tim McCormack with us to talk through the issues associated with the International Court of Justice and the International Criminal Court, which has had a lot of play in the media and social media commentary in recent times particularly, and the confusion that's surfaced around the way it operates and some of the decisions and orders that are getting made through those instruments of both the United Nations and the Independent Court of Criminal Jurisdiction for War Crimes that's been established. The good fortune that we have with having Tim with us is that he was intimately involved in the drafting of the Rome Statute for the ICC, so we'll tease that out. But before we go there, to finish off our conversations around the ICJ this week, we're just going to talk about what is the actual process through which this court works on a contested matter such as the South African case against Israel alleging genocide. So what are the steps involved in that? What can we expect in the timelines that will follow for this process? So, Tim, how does the court get to a point where they can actually properly try the substance of matter? What are the steps involved?
And so when an applicant state lodges an application for the court to decide on a contested question of international law, that initiates the process, and usually there's at least one preliminary step before what we call the merits phase of the case, where the substance of the issue really gets dealt with. The preliminary stage that usually occurs is the what's called the jurisdictional stage, where the court decides whether it actually has jurisdiction or not. So last week I was talking about three alternative ways that two states party to a dispute, an international legal dispute, can consent to the court exercising its jurisdiction. If the case comes to the court by way of special agreement, jurisdiction is pretty obvious,
Right.
because both states have accepted that they want to submit the dispute to the court, or they've agreed that they're going to do that, and the special agreement sets the parameters of the issues that they are asking the court to decide.
Right.
So there isn't a need then for a separate procedural hearing about whether the court has jurisdiction.
Right.
If the case comes to the court by either of the other two ways, that is, either by either by a clause in a multilateral treaty that gives the court jurisdiction in the event of a dispute about interpretation or application of the treaty's terms, or if the case comes by way of a claim that both states party to the dispute have accepted the jurisdiction of the court by declaration.
Right.
Often the respondent state wants to challenge the jurisdiction, and they actually don't have it because this case isn't about this, or whatever the grounds of that are.
Right.
Or when we made the declaration accepting the jurisdiction of the court, we made a reservation that excluded from the court's jurisdiction matters essentially within our domestic jurisdiction, or for example. So there's often a jurisdictional phase where the court hears arguments about whether it has jurisdiction and makes a decision whether it has or whether it doesn't.
Right.
But there is also a second preliminary phase, which is one that South Africa exercised, which is a call for provisional measures, where the court is asked to make orders. It's a little bit like a proceeding in a national court for injunctive relief. So the argument is that unless the court orders provisional measures now, there is a chance that the circumstances on the ground will change irrevocably, so that will adversely impact on the merits of the substantive issue.
Right.
And South Africa asked for provisional measures, and the court has made three separate orders in, if I remember correctly, January, March, and May 2024. And the test for the court under the statute is, I'm just trying to remember exactly what the wording is. Should have checked that before I came. But it's all about whether there is a reasonable possibility that the merits might be affected unless the provisional orders are made.
Right.
It's obviously not a finding on the substantive merits at all. It's about trying to protect or preserve the situation to enable an objective decision of the court on the merits.
Right. And to set that up, looking at that first phase where South Africa was looking at provisional orders, this is a good way, I guess, of explaining this process by looking at that case. They did have to say, is there a dispute, and find that there's a dispute before they could deal with it. And they were drawing on that, as we talked about last time, the fact that that mechanism is there in the Convention Against Genocide, for having that interpretation done by the court. And so they had to work out, there's a dispute between the states. And then I think one of the other elements they had to satisfy themselves on was to say, well, are Palestinians a people to which a genocide protection
genocide can be directed,
so that they were a people that could classify as being a genocide. I guess that a genocide crime could be committed against, and they ruled basically, yes, there's a dispute. Yes, there are people that can be protected under the Genocide Convention. And I guess then they looked at those provisional orders, and they effectively threw out all the provisional orders but came up with their own. So the court has the ability to create their own provisional orders. So, and that was effectively, that first procedural step. And I've seen conversations around then where we go next. And I guess the next step, as I understand it, is they're going to test whether or not there is kind of like a what we would call in a common law jurisdiction a prima facie case on the merits, to whether it goes forward to a full trial. Would that be right?
Yeah. And there'll be a question about whether Israel participates in that process or not. They did, as respondents state, in the provisional measures stage. But I don't know whether they'll continue to be involved, because they might choose not to.
Right, so there's that step. And then you go forward to, let's say they find a prima facie case, which is, again, not finding on a conclusion on the merits. And they then move forward to an actual trial. And then we get to that. And I gave the example of the Bosnian genocide case took about 14 years to resolve. Is that the sort of timeline that we're looking at now, or what's your estimate of the process?
I don't think it'll be 14 years. I think it'll more likely be 2 to 3.
Right.
But it's certainly, and it's not 6 months. That's for sure. Well, if it was 6 months, it would have happened, wouldn't it?
Right.
Because the last order on provisional measures was given in May last year, and we're already, that's 12 months down the track.
Right. And I believe they've made an order now to delay the next step, which is they claim that South Africa hadn't complied with a proper memorial in relation to their claims and provided that to Israel. So that's now extended out to January next year or something. So that's another, I guess, illustration of some of the procedural dimensions.
Yeah, the provision of a memorial, it's not the construction of a monument. Talking about the provision of written arguments.
Right, and evidence.
It just happens that the terminology in the ICJ statute is a written memorial.
Right.
I think it seems to me to be an innocuous name, but anyway, the written arguments have to be provided to the other side, and within a certain time frame, and then the other side has to have a certain amount of time to be able to respond with their own written arguments. So yes, that's got to be strictly enforced, otherwise it's unfair process.
Right. Okay. So there are all these steps then that we're moving through. So when and we did see a clip from the former president Joan Donoghue, who said that first step didn't find, as a lot were claiming, that they'd established plausible genocide at all. That wasn't what they'd found. So people confusing it, there was some kind of substantive consideration of the matter. There's a long process to go through. So, pump your brakes and let's wait and see what they do.
Yeah. No, the provisional measures isn't about substantive findings.
Right.
Provisional measures is about trying to ensure that the situation on the ground doesn't preclude an objective assessment of the merits.
And they did talk about, I think one of the measures that they did introduce themselves was calling on preservation of evidence, for example, that sort of thing. So that underlies what your point there.
Yeah.
All right. Well, so I guess hopefully now we understand that we're always off from getting actual substance and merits of this case looked at in depth and detail and resolved. So then coming to the ICC, which has kind of been called into play as well through warrants that have been issued against the Prime Minister of Israel, Netanyahu, and the former Defence Minister. And, the fact that this is actually like criminal proceedings, so different from the ICJ, and you have to actually go after individuals for criminal responsibility. So in that respect, you were intimately involved in the Rome Statute, as I mentioned. And so there are some set up jurisdictional things here too, and I was involved in advocating for Australia signing up to this in hearings in Parliament while I was still in the army, because I looked at the situation we were in Somalia, where there was no state, no judiciary, etc., to deal with someone like a Gatali, who I was dealing with in Somalia, who was a genocidal maniac, and would have been great if we could have sent him off to a tribunal to be dealt with,
Sure.
rather than try and find a way to get that happening in Somalia. So I was advocating for that because there was mechanisms that we believed were going to be in this process to safeguard respect for our own system. So just could you explain that jurisdictional setup that you played a part in the Rome Statute?
Yeah, perhaps just a preliminary comment, if I could, Mike. You talked about the ICJ going to a full trial. I mean, trial is probably the wrong word. I mean, it's a case between states, because the jurisdiction of the ICJ is the judicial determination of whether or not a sovereign nation state is responsible for violations of international law. So it's not a trial of the state. Right. It's a case to decide whether or not the state has or has not complied with its international legal obligations, treaty or customary international law obligations. That's very different to the ICC, of course. The ICC is a criminal court and is set up to try individuals for alleged violations of the Rome Statute, the multilateral treaty that establishes the court. Multilateral treaty was negotiated in Rome in 1998 over a 5-week diplomatic conference, and the categories of crimes are in chronological order through Articles 6, 7, 8 and 8b. Genocide, crimes against humanity, war crimes, and the crime of aggression, all as defined in the Rome Statute, but very much based on treaties and customary international law. The way the jurisdiction of the ICC works is there are three critical issues to ICC jurisdiction. One of them, first of all, is the consent. So not unlike the ICJ, that can only conduct a contested case where it has the consent of the parties. The ICC also needs the consent. However, it's slightly different than the ICJ, because the ICJ requires the consent of both states. The ICC doesn't. The Rome Statute says that all that is required is the consent of either the territorial state, the state on whose physical territory the alleged crime occurred, or the state of nationality, the state whose national or nationals allegedly perpetrated the offences. So if one or other of those states has consented, there are two ways to consent. I know it sounds complicated, but it's not really once you understand it. A state that becomes a party to the Rome Statute automatically automatically consents to the jurisdiction of the ICC. Doesn't mean the ICC has jurisdiction, just the state's given its consent.
Yep.
If neither of those two states, I mean, some circumstances of civil war, of course, we're talking about the territorial state and the state of nationality is one and the same.
Mm-hmm.
So in those cases, only one state can consent.
Right.
But in circumstances where those two states are different, if either of them has consented, then the next requirement is that one of three. Sorry, just to be clear on the consent requirement, I said there are two ways it can happen. One is if either state is a state party, it's already accepted the jurisdiction of the court. If neither of those states has accepted the court's jurisdiction, so if neither of those states is a state party, either of them can accept the jurisdiction of the court by declaration.
Okay.
Like a declaration ad hoc. Ukraine did that actually first up. Now Ukraine has become a state party, but back in 2021, I think it was, they made a declaration accepting the jurisdiction of the court in respect of Russia's invasion of the Crimean Peninsula.
Right.
And then after the Russian invasion in February 2022 of the eastern provinces of Ukraine, Ukraine made a second declaration accepting the jurisdiction of the court in relation to that time period.
Right. Mm-hmm.
So if the consent requirement is met, the second requirement is that one of three triggers have to have occurred before the prosecutor is authorised to open a formal criminal investigation.
Right.
The first of those is state party referral. So a state party to the Rome Statute refers a situation to the prosecutor. So we believe that there are Rome Statute offences occurring. Please check it out.
Mm-hmm.
The second possibility is UN Security Council referral, where the Security Council adopts a resolution authorising the prosecutor of the ICC to open a criminal investigation. That's happened in relation to the situation in Darfur in Sudan, 2005, and in Libya in 2011. Obviously, if a situation involves a vested interest on one of the 5 permanent members of the Security Council, there's no way the Security Council is going to refer the situation.
Right.
The third possibility is that if neither of those referrals happen, prosecutor can go to a pre-trial chamber of 3 judges and convince at least 2 of them, a majority, that there is reasonable grounds for believing that Rome Statute offences have been perpetrated. So on the basis of open source material, this is not on the basis of criminal investigation. He hasn't got authority yet to open a criminal investigation. On the basis of open source public domain material, there are reasonable grounds to believe that Rome Statute offences have been committed.
Right.
Please give me the authority to open a criminal investigation, and the judges decide whether to do that or not. And that's happened in a few situations as well.
Right.
One of those 3 has to occur. They're all equally valid in terms of giving the prosecutor the authority to open a criminal investigation.
Yeah.
But they're the sort of, in addition to those 2, the critical test is the third admissibility criterion is what we call the complementarity formula.
Right.
The word complementarity doesn't appear in the Rome Statute. Instead, in a couple of different places, the statute talks about the court being a complement to, not, you look great today, Mike. Not that sort of compliment.
Never happened, but
no I's in that compliment. It's all E's, and an O. But the ICC is a complement to, or a supplement, if you like, to national courts, and there's a test that has to be applied. The judges have to be satisfied that both the territorial state and the state of nationality, it's not one or the other this time, it's both of them, because both of them have a better claim on jurisdiction than does the ICC.
Right.
Judges have to be satisfied that both the territorial state and the state of nationality are unwilling or unable genuinely to conduct the investigation and or trial proceedings themselves. Now, we understand, your example of Somalia, a failed state situation, that's a classic example of what it means to be genuinely unable to conduct the trial. Statute talks about that, gives gives that example, not Somalia, but describes a situation where the fundamental, forms of government have broken down.
Right.
But in relation to a lack of willingness, the statute has a number of different sort of examples of that.
Right.
If a national state either doesn't initiate proceedings themselves or initiates sham proceedings,
Right.
which are designed to shield individuals from criminal responsibility,
Mm-hmm.
the court is able to interpret that as an example of a lack of willingness.
Right.
But that's as you can imagine, that's a contentious judgment call on the part of the ICC.
How do you assess it? Yeah. Effectively. Yeah.
And it isn't assessed at the stage of the issuance of arrest warrants. It's assessed at the stage of the next stage, which is like a committal proceeding, a pre-trial stage. If the individual who is the subject of arrest warrant is handed over to custody of the court, then there's a preliminary stage which is called the confirmation of charges.
Mm-hmm.
Each stage in the decision to issue arrest warrants, confirm charges, or try someone, the burden of proof increases from reasonable grounds of believing that Rome statute offences have occurred to substantial grounds of believing this individual is criminally responsible for these offences,
Right.
to beyond reasonable doubt.
Yeah, that whole journey. So in the context of that article of the Rome statute, I think it's 14 or
17.
17?
Yeah.
Right. So in making that assessment of the capability, the willingness of a state to do this, is there, a formal structure by which they can go about doing that? And one of the examples we talked about last time was that there was an invitation for servants of the court to come to Israel, for example, in, I think it was May last year, to come and talk through, well, what are your mechanisms and what are you doing? What investigations are underway, and how do you expect these to pan out? And that they reneged on that arrangement and didn't come. And then we talked about what we know, and Mark Binskin in his report went through what's happening, in relation to those investigation processes and how they stand alone from, there's no military command interference capable in relation to that independent structure, and there are about 1,000, inquiries underway into that kind of thing, and then other military inquiries into processes and procedures that are independent of this kind of subject matter that we're talking about, criminal stuff. So how is the court equipped to actually go out and engage with countries to find out about that kind of thing going on and interrogate it?
Yeah, I mean, there's two aspects to this, I think, that are really important. One is the responsibility of the prosecutor,
Mm-hmm.
because that test of whether a state is willing or not
Mm-hmm.
has to be determined by the prosecutor
Right.
initially for seeking issuance of arrest warrants, and also certainly confirming charges.
Mm-hmm.
But it's also there's a second application of the same test by the judges. Judges also have to be satisfied of that.
Mm-hmm.
So I think the prosecutor said publicly a few times that any state that is prepared to take seriously its national responsibility and national priority in terms of better claim on jurisdiction, he welcomes that,
Mm-hmm.
and is open to engaging. And I don't think it's a secret that the prosecutor is very pleased with the Australian and British approaches into alleged war crimes in Afghanistan, about, taking seriously a rigorous investigation of those, or an inquiry in the case of the UK at the moment.
Mm-hmm.
But yes, it's a call that the prosecutor has to make. And
how would they normally go about doing that, though? What's the mechanism by which they would try and engage with another country to determine this? And is there sort of a framework for it, or is it an informal sort of thing?
I think it's an informal thing, and I think it's on the basis of, initial contacts between diplomatic representatives in The Hague who are coming to visit the prosecutor,
Right.
and often, from the country concerned, delegations of legal advisors from foreign ministry, from military, from the Department of Justice or equivalent, Attorney General's Department in our case.
Right.
So, yeah, I mean, I've seen those processes work out under all three prosecutors because I served as special advisor on war crimes to all of them. I was appointed by Mr. Ocampo in 2010,
Right.
and reappointed by Madam Bensouda in 2012,
Right.
and then reappointed by Karim Khan in 2021 when he took over, before I finally finished up in September 2024.
Right.
But they were always informal, as a group of colleagues from the Office of the Prosecutor who would meet with those delegations and talk through what are our processes in the Office of the Prosecutor for so-called preliminary examinations before there's authority to open a formal criminal investigation.
Okay.
What our processes are when we open a criminal investigation, what we're keen to learn from you about what your approach is at the domestic level, national level.
Right. Okay. So really the onus is on the prosecutor and his office to do the assessment of whether a state's willing then to and capable of proper prosecution and investigation. So it's really the onus is on the prosecutor to take those steps.
Yeah.
Right. But it's not something that he has discretion to do. He's really obliged to do it, isn't he? The prosecutor, or her when it's a her. But
discretion about whether to check with the lack of willingness.
Satisfied that
yeah.
the country has the capability and willingness to deal with the matter.
Yeah. Absolutely. So, I mean, it's if he doesn't do that, then the risk is that when it comes to some subsequent stage, the judges let him know that he's overstepped his authority.
Yeah. Well, actually,
I'm talking about him because at the moment it is a bloke. So.
Yeah, it is. Yeah, Khan. So, and I noticed too that we've just had sort of a decision handed down by the court that they do have to go back and reassess the jurisdiction point in the lower chamber of the ICC that on this, specifically on the jurisdiction point.
There are three chambers at the ICC: the pre-trial chamber, the trial chamber, and the appeals chamber.
Right.
So the 18 judges are split across those three chambers. The president of the court assigns, judicial officers to particular chambers.
Right.
The pre-trial chamber, not surprisingly, deals with all the pre-trial issues.
Right.
So they deal with applications for arrest warrant. They deal with pre-trial hearings about confirmation of charges. They deal with initial jurisdictional questions.
Right.
And then the trial chamber, obviously, well, I mean, I think the name is self-descriptive. They deal with the trial proceedings.
Right.
And the appeals chamber hears appeals from the pre-trial chamber as well as from the appeals chamber, from the trial chamber.
Right.
Yeah.
So then it would be accurate to say, like if we're looking at this case study, that the pre-trial chamber was obliged to actually consider those jurisdictional issues, the complementarity stuff as beforehand.
Yeah, one thing that the prosecutor did that she then, Fatou Bensouda did this, took this step back in 2019, before she opened a formal criminal investigation in the Palestine situation.
Right.
She went to the pre-trial chamber. There's a provision, Article 19, Paragraph 3, which says that the prosecutor can request clarification on whether or not the court has jurisdiction. And she did that because she understood, as did her predecessor, Mr. Ocampo, that the question of Palestine's status was, was uncertain. A contested one.
Uncertain.
Yeah. And so she wanted to, rather than spend years on a complex criminal investigation, she wanted to be confident that the court was of the view that it had jurisdiction.
Right.
That in those the pre-trial chamber issued written reasons for its decision and said that this court is not competent to decide the international legal status of Palestine. That would have to be for the ICJ.
Right.
For the purposes of the Rome Statute, Palestine is a state party because when it deposited its instrument of accession, the Assembly of States Parties accepted it.
Right.
Canada, in fact, was the only state party that objected to it.
Right.
having accepted and admitted Palestine as a state party for the purpose of the Rome Statute, the court has jurisdiction.
Mm-hmm.
And so I mean that I think that was a good, a wise decision on the part of Mrs. Bensouda,
Mm-hmm.
and I'm glad that she went through that process.
Right. So, so we understand then that this jurisdiction thing can be dealt with by the pretrial chamber, should be dealt with by it. But in this situation, it seems like the appeals court has said, well, they didn't do it properly, or didn't do it at all, or there's something missing there, or at least something that needs to be tested properly at that level, and have referred it to that pretrial
back
chamber
to the pretrial chamber. I mean the decision of the pretrial chamber in 2019 was not appealed.
Right.
And I mean, not surprisingly, Palestine didn't want to appeal it.
Right.
And no other state party chose to appeal it. There were a number of state parties that made written submissions and actually appeared in person before the pretrial chamber,
Right.
arguing, different positions on whether or not the court had jurisdiction.
Right.
Maybe one of them could have instituted appeal proceedings. I'm not sure about how that will work. But,
Right.
Yeah.
But in this case, we are, I guess, going to get a proper contest at the pretrial chamber now around properly assessing that willingness capability element, I guess, is really the centrality of this, the complementarity.
Yeah.
And I guess we're all going to be looking at closely because, as I said, I argued for this on the basis that our national jurisdiction was going to be respected as part of it. I think we're all asking questions now. Well, will it really, depending on, as I say, the hot politics of the situation?
Yeah.
So, yeah. Oh, well, it's, thanks for unpicking all that for us. And
it's been sort of bread and butter for me. I was never paid. My job at the ICC was pro bono for 14 and a half years. So, I mean, bread and butter's the wrong term, perhaps, but but I've lived and breathed those provisions of the statute. I mean, I guess as special advisor on war crimes, the key provision for me is Article 8, which sets out all the offences that are war crimes, either in an international or a non-international armed conflict in the Rome Statute. But on the sort of jurisdictional questions that so threshold and substantial, that, I mean,
be done right.
They have to be done right.
Confidence, yeah.
And, they've been significant to me because I've been doing some work with the approval of the prosecutor here in Australia with the Office of Special Investigator, and also in London with the inquiry into the allegations in Afghanistan. And so, I understand the sensitivities for both states parties to the Rome Statute about how these provisions are interpreted and applied by the prosecutor.
Right. Well, go to the example, one of the episodes that specifically is to your point about the processes in train here in Australia. Talk about the allegations against Trooper Schultz and the fact that the incident goes back to 2012.
Yeah.
And they've just been begun really in April. And so we've seen a 13-year time period of thorough investigation and dealings with that. So I guess in making these assessments, complementarity assessment, when you're looking at it from the point of view of ableness and willingness, you've got to factor in reasonableness in terms of that process.
Yeah,
So,
that's true. And that process clearly takes time, doesn't it?
Yeah. And I know that the authorities have been, diligent in pursuing it.
Yeah, and I mean, our experience is replicated in the UK. The UK's, the period of time that the inquiry in the UK is looking at is 2010 to 2013. And they're only at the inquiry stage.
Right.
I mean, they're a few years behind us in terms of the processes we've been working through.
Right.
So, I mean,
keep it all in perspective.
this stuff takes time.
Yeah, no worries. And look, I guess one of the contributions the ICC process, I think it was going to make too, was in setting out all of those elements of the crime, which is something I paid more attention to than the actual structure of it, not thinking we'd have to worry about that. But made a real contribution to distilling and teasing out some of these crimes, like, and I think the one they had to take the longest over was the crime of aggression, which had never been spelled out before and was only really created sort of World War II, post-World War II. So there's a contribution there, but, if you can't guarantee the efficacy of it all, then we'll be sadly disappointed, I think, in what we had hoped for.
Yeah, I mean, I completely agree with that. I think that the subject matter definitions of the crimes are very helpful because that's the starting point for many states, Australia included, in comprehensively ensuring that at the domestic level all the crimes in the Rome Statute are covered, precisely so that we can benefit from complementarity if we choose to exercise national jurisdiction.
Yeah, training up.
So there's a lot of work went into the definitions of crimes. They're not perfect. I mean, there's some. If I had if I could wave a magic law reform wand over the Rome Statute, there'd be some things I'd fix up in Article 8 especially.
Right.
Because at the time they were overlooked, they weren't thought about.
Right.
There is definitely some issues.
Might be time for a new international conference to review the fact that it's been in operation.
Can you imagine yes and no? Because I'd say if we hadn't created the Rome Statute in 1998, there's no way it could happen now. Like in the current multilateral environment, when the rule of law in armed conflict is being challenged and tested more than perhaps, it has ever since 1949. I don't know whether you can say that or not, but it's certainly a period of testing. And in the contested space that currently flavors and taints multilateralism, the idea of creating a permanent international criminal court right now, no way.
Forget it. Yeah.
So the decade of the 1990s was halcyon years for the establishment of new institutions and new international law.
Right. Oh, let's see if we can repair it. But well, thanks very much for that, Tim. And look, given your unbelievable breadth and depth of experience in this and your expertise, hopefully we can get you back in. I know you love the Apple Isle for good reason, so we'll probably tap into you by Zoom on occasion.
Sure,
but,
sure. And look, I do come to the national capital from time to time. I come way more often than you come down to the heart-shaped island.
Yes.
Let's be fair. But so I'm happy to come in person or do it by Zoom, whatever you want. That's fine.
No worries. Well, we're really happy to have you as part of the life of UC now as well, and Bill Shorten's really enthusiastic about that. So we'll look forward to talking to you again, and hopefully we'll get a lot of help on teasing out some of the issues as they get tested, emerging from all of our conflicts that we're dealing with, the conversations we're having around Ukraine, etc. So we'll see you again next time. And thanks again, Tim, for being with us. And
pleasure.
Stay tuned for more. Thanks very much. Cheers.